The three C's that make medical malpractice cases difficult: cost, consent, and courage. Hi, I'm Scott Peterson. I'm a plaintiff's litigation attorney in New York. Today we're going to talk about the three C's that make medical malpractice cases so difficult: cost, consent, and courage. Number one, cost. Medical malpractice cases are expensive. They are more expensive than any other case to pursue. Why? Because there are extra thresholds that attorneys have to go over in order to even bring the case in the first place. That includes having a physician who is licensed review the records in the case and make an assessment that there was in fact malpractice. This is before the case ever gets into a courtroom. That costs money. Once it gets into the courtroom, there are depositions. There are also expert fees. In order to prevail as a plaintiff in a medical malpractice case, you have to bring an expert into court. That expert has to be willing to testify that the defendant doctor deviated from accepted medical standards. It often costs quite a bit of money to get experts to come in and do that. Number two, consent. If you hit somebody with your car, your insurance company has the right to settle the case with that victim without your consent. They can simply call them up, offer them some money, get a settlement, and put the case behind them. That's not how it works in medical malpractice cases. For the most part, medical malpractice cases, doctors have what's called a consent policy. What is that? That's a policy that says that the doctor's insurance company cannot settle the case without the doctor's consent. And why is that important? Well, that's important because there may be oftentimes when doctors don't think that they did anything wrong, despite the fact that perhaps the insurance company does. Doctors, like many other professionals, believe firmly in what they're doing. They rarely think that they make mistakes, particularly in the context of medical malpractice cases. And the lack of doctor's consent leads to many cases going to trial that probably shouldn't. Number three, courage. It takes courage for a doctor to come into the courtroom and testify against another doctor and say that that doctor made a medical error. It also takes courage for a jury of 6 people who are not doctors to say, yes, the doctor made a medical error. The doctor will have provided his own testimony or her own testimony, as well as an expert in support of their case. And they will say to the jury that they're the experts. They're the ones who are medically trained. And they will suggest that it's not the jury's right to say that they made a medical mistake. So it takes courage for juries to find that doctors deviated from accepted standards of care and committed malpractice. It happens. But it happens much less frequently than plaintiffs' verdicts in other kinds of cases. The statistics are tough. Most cases that go to trial in the medical malpractice field are won by doctors. But that doesn't mean that we should stop pursuing them. There are bad doctors. There are doctors who make bad mistakes. And unless we continue pursuing those potential cases and trying to make right those mistakes, they'll be left unchecked. But it's important to keep in mind the three C's when thinking about or talking with lawyers about a potential medical malpractice case. They are not easy cases. Those three C's represent just a couple of reasons why. Nonetheless, we like talking to people who have potential cases. We like trying to help people when we can. So if you have a potential medical malpractice case, or you have some questions about a potential medical malpractice case in New York, give us a call. We're happy to talk with you.